Here it says that you pulled out a handgun with a silencer attached to it and opened fire. Am I reading that incorrectly?
A silenced handgun, a terrified family trapped on a highway, and a former border officer whose split-second decision nearly turned deadly. Today, you're about to witness one of the most intense road rage courtroom cases you'll ever see, a case where emotion, fear, and responsibility collide. Pay close attention, because this judge isn't letting anything slide, and the moment she starts digging into the details, everything changes.
All right, the court is calling 2025 CR 002103, State versus Jeffrey Patrick Smith. Can I have parties announced?
Tilden Schaefer for Mr. Smith, Your Honor.
Kurt Grancy, co-counsel with Tilden Schaefer.
All right, counsel, have you received all discovery and did you review it with your client?
We have and we did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Smith, did you review the application? Sign it. It happens. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
You're not.
Any objections?
No, Your Honor.
Did you review the court admonishments with your attorneys? Did you understand it and sign it in all the appropriate places? Did you understand in count one, you're charged with aggravated assault with a deadly weapon? That is a second-degree felony. Range of punishment. Just 1 second. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will.
Right here is where the temperature in the courtroom shifts. The judge isn't just reading facts. She's dissecting his judgment. When she asks how an argument escalates into drawing a gun with a suppressor, she's signaling that the fear for my life defense isn't adding up. Judges look for proportionality, and pulling a suppressed firearm over brake checking, that's a massive red flag.
Plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No,
Anyone promised you anything other than the plea?
no, ma'am.
Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, there's a $1,500 fine. State is proceeding on count one only. There's an affirmative finding of deadly weapon. There's no application for community supervision. You don't qualify for community supervision legally. There is an application for deferred adjudication, and the state is recommending deferred adjudication. There's to be restitution, if any, to the complainant. Did you understand that to be your plea?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
None ruled on, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for term.
This part is crucial. Flashing a badge during a heated confrontation. Judges absolutely hate anything that resembles abuse of authority. Even if he wasn't acting as law enforcement, it gives the impression he tried to intimidate or control another driver, and that destroys credibility fast. This is where his past as an officer starts working against him, not for him.
Community service restitution, no contact with the complainant, MRT, anger management, driver safety and gun safety courses, forfeit the weapon and harsh horseshoe bay badge credentials, no firearm possession, no law enforcement employment. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense and count one, how do you plea? State any evidence.
State offer states exhibit one.
No objection, Your Honor.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? You need to speak up.
Yes, ma'am.
Did you understand by entering this plea, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding the guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
All right, first, why should I follow this plea bargain agreement?
I've asked personally, and he would like to.
Okay. Anything from Vince?
Judge, I think this is a situation where my client greatly regrets what he did. It's a situation that got out of control. And I think based on his background and age, it's one of those, we should have made much wiser decisions. He doesn't have a violent background. And I do know, and I think the court can tell from how he's answering questions, there's quite a bit of regret in this entire affair, Your Honor.
All right. So why did it come to this?
Your Honor, it was just a messed up situation that night. I wish I could have made a different decision. You know, my son was in the car with me. I was worried about his safety 100%. And I'm a minute that hasn't gone by since this has happened that I wish I could have made a better decision that night.
Okay, I understand what you're saying, but I still don't understand how an argument.
The suppressor changes everything. A normal gun could be argued as a panicked self-defense move, but a suppressed weapon? That suggests intent, training, and preparation. Judges know suppressors aren't casual car carry items. The presence of one raises a seriousness dramatically, whether he intended harm or not.
Argument on the road comes to a pulling of a weapon. I just don't understand that. And they're asking for a driver safety course. They're asking for a gun safety course. They're asking that you forfeit your horseshoe bay badge credentials. And they're saying that you flashed a badge and that you were no longer employed with them. So I'm just trying to figure out what conditions would be appropriate for you. This is why I asked these questions, because
I only
there's a lot listed.
used the old trying to diffuse the situation. I thought it would help. That was it. There was no other reason behind it.
Why did you still have the badge?
It was given to me by my chief of police at the time as a memento, because that was my first job there before I went to Border Patrol.
So where do you work now?
I've left I left Border Patrol in 2016. I went back to construction. I'm a home inspector for new homes. Till this happened, I was planning on going back to actually apply for ICE. That's null and void.
I mean, but here it says that you pulled out a handgun with a silencer attached to it and opened fire. Am I reading that incorrectly?
No, so Judge, he has a suppressor, and so his parents live near Kerrville.
Okay.
That's what the mother and father, they had gone out to her birthday celebration that night. He was going home with his son, and they have it's in a rural area, so they actually have kind of a setup where they do target practice. The suppressor has more to do with not making loud bangs. That's why he had, and it's legally owned. He's got the stamp for it. I have it in my file back, trial file. It's not illegally possessed. Otherwise, I guess the feds would be involved in this case, Your Honor. That's why I had the silencer. I can tell you that There was a perception on my client's part that the kid was tailgating. Then there was a brake check, which you can see from the statement and the police reports. And then the kid comes around really close, rolls down his window, honks at him, yells, starts cussing, and it kind of goes from there, it goes kind of south. I think
The defense tries to introduce the victim's social media gun photos, a risky strategy. Judges generally dismiss anything that isn't directly tied to the incident. Unless the victim aimed a gun that day, the photos don't reduce Jeffrey's responsibility. This move can sometimes backfire, making it seem like deflection instead of accountability.
I think my client thought he could handle the situation. He thought he would diffuse it with the badge. That didn't work. And then at the moment when this all happened, apparently the young man had a phone in his hand. This was at night, and he made a gesture kind of with his hand to the side, which at that moment in time, my client, who was already kind of freaked out, thought it was a gun. And this was an apparent danger case, Your Honor. Police didn't find a gun in the kid's car. But that's what we saw. We actually, in the subpoenas, dug up extraneous acts where a kid had got in trouble at school for posting shots on social media with him with guns. And he's holding it the same way he was holding the phone. When he's talking to the police officers, he's holding it and he's pointing like this. So that's the gesture my client saw in that moment. He made a mistake. We've spent a lot of time on this. The state has spent a lot of time. They showed us a new witness who was the girlfriend of the young man in the car at the time that nobody had ever found. We'd always wondered, why weren't they looking for the girlfriend? We couldn't find her. We didn't know her name. Ms. Alvin did a great job preparing for trial. And that's kind of why we're here today, Judge. I think both sides have kind of met in the middle. Again, my client doesn't have a violent background. It's just thank God that he didn't hit the kid. So that's why we're here.
Oh, is there something else?
Well, I mean, I'm not sure it's clear. The gun was in the car because of going out target practicing, but he had gone and met his family for dinner, and he was going home, and they were in the back seat of the car, in a bag.
And there it is, no jail time, but only because the victim agreed to a deal. The judge made it crystal clear. His freedom wasn't owned, it was granted. This case is a reminder that a single moment on the road can change lives forever. What do you think? Was this mercy or a mistake? If you found this breakdown insightful, hit like, share your thoughts in the comments, and subscribe for more real courtroom analysis.
Judge, I think it's going to take a couple of months if the court would entertain that. He started this job about June, maybe, and so there's been some lag time, and I mean he is the independent contractor, so lag time and taking the jobs and getting paid from the
All right, just 1 second. Excuse me. Everybody on this side, y'all need to move because probation can't see and they can't hear what's going on. All right, so when do you think it will be? Oh, and state your excuse. When do you think he will have that?
If I had, I would say a minimum 2 months.
Yeah, minimum, 60 days.
All right. And that's 60 days from today? All right.